All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CV16 0406, Holcomb v. American Valet. Counsel, each side is allotted 20 minutes for oral argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, you'll need to keep track using the time on the podium clock for any rebuttal. Out of respect for counsel, those in attendance, please make sure your cell phones are off or on vibrate. Counsel, we have read the briefs and conferences case this morning. That's why we're a little bit late in getting started. I apologize. We encourage you to keep that in mind as you present your arguments this morning. The proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you will be you're representing. With that, the appellant's counsel may proceed.
Good morning, Your Honors. Scott Harris and co-counsel Todd Weintraub for appellants Donald and Alma Holcomb. I would like to reserve 5 minutes or so for rebuttal. The central issue in this case, the central question in this case, is why did American Valet go to such great lengths, take such great effort to ensure that there were seatbelts in the shuttles for the Mayo Clinic account when they did not take any effort, they did not make any efforts to do so in the other hospital accounts that they serviced? The answer is quite simple, and that answer is that they knew that they had an obligation, they knew that they had a requirement, they knew that they had a duty to provide seatbelts in the shuttles for the Mayo Clinic account.
Well, is whether, there seems to conflate two questions to me. The first question is whether, because of the relationship between American Valet and the Holcombs and the hospital, that they had a duty to them, but whether that duty is breached by having seatbelts or not seems to be a different question. Aren't those two separate questions?
I agree, Your Honor. I believe it is two separate questions. I believe the issue before this court today is whether there is a duty, whether that duty exists. However, I do believe that when we answer that question, you get to the answer of the breach as well, although I would agree that that really is something probably for another day.
Does the duty arise only because of a contractual relationship between Mayo and American Valet? Are you saying that's the basis of the duty?
Well, there are interestingly, Your Honor, there is no statute, as we know. There is no Arizona statute. There is no federal statute. In fact, it's not even spelled out in the written contract, per se, to have seatbelts. But the duty arises twofold, and I think both apply in this particular case. One is out of conduct, and that's where we get to the restatement 324A argument that we'll talk about. The other is arising out of contract. So I think there are two ways in this particular case that the duty does arise. Either is acceptable.
But the contract doesn't say they have to have seatbelts, correct? Or
the contract, the written contract itself is silent on whether or not seatbelts were required. That is true. And we've never made an issue that the contract itself.
Then how do we know that there is the contractual relationship? Or are you basing it entirely on, is it Mr. Bergstrom's?
Your Honor, Mr. Bergstrom is central to this case. He's central to the facts. He's the only one who has provided a factual basis, a foundational basis for the relationship between Mayo Clinic.
If we were to conclude that his testimony is not admissible, what would that do to your position?
Well, if, and I think that's a big if, his testimony were not admissible, then that would be very detrimental to our case.
Is there anything else that supports that there's a contractual obligation that American Valet agreed to provide seatbelts whenever they were transporting Mayo patients?
There is nothing in writing. It's simply out of their conduct, and what Mayo and American Valet had subsequently agreed to by virtue of how they did their business. They modified the agreement in order to further Mayo's desire to have seatbelts. And yes, that evidence, that foundation, is provided by Mr. Bergstrom.
Isn't the use or not use of the seatbelt, whether it was required by practice or they understood that that's what Mayo wanted, all those factual questions that really aren't before us?
I'm sorry?
Whether the parties understood that they should have seatbelts or not, aren't questions related to that, not for us, but for another day?
I'm not sure I understand the question, Your Honor. Whether they understood their...
Yeah, I mean, we seem to be arguing over whether whether seatbelts were required or not.
True.
But that seems to be a factual question.
It is a factual question.
It's really not for us to opine one way or the other.
Well, I respectfully disagree, Your Honor. That is the basis of the duty. In this instance, in order to find the duty, you have to look at the facts of the case. Because...
Well, but then doesn't that conflate the question of whether there's a duty or not, which is a legal question?
Yes.
From the factual question, which I think you want to discuss, whether that duty was breached. And do you win if we find in your favor on the first question?
I think the answer to that, Your Honor, is yes. If there is a duty to provide seatbelts by virtue of the conduct or the contract.
Well, is the duty not to cause injury, and whether seatbelts should or shouldn't have been used is a question of whether there's a breach of that duty.
Well, there's a violation. Liability would attach pursuant to 324A if the American Valet didn't do what they were supposed to do in order to protect third persons. So if they didn't do it, then that would be a breach. The first question, though, Your Honor, is whether they had an obligation to do something. Did they have an undertaking here? Did they undertake a course of action under 324A? There are actually 4 parts of 324A that are quite important.
But are you saying the undertaking is to have seatbelts installed, or just the undertaking is to transport passengers?
The undertaking here, is to provide seatbelts in the Mayo Clinic shuttles. That is the undertaking that American Valet undertook under 324A that gets them to an obligation to third parties like the Holcombs.
Isn't that aren't you taking on a bigger burden than you need to?
In terms of creating a duty?
Yeah, I mean, it seems like...
Well, and if I understand the question, Your Honor, the argument then at the trial court would have simply been, was the driver negligent in his operation of the vehicle by slamming on the brakes and causing the Holcombs to fly out of their seats?
And then the argument would be they breached that duty by not having seatbelts. which is a separate question from the duty.
Well, but what would happen, I believe, Your Honor, is we would circle back, and if the argument was that they breached that duty by not having seatbelts, the defense to that position would be, well, we did not have any requirement to have seatbelts. There was no duty, so we have to decide the duty issue first.
But is there a duty to safely transport and to decide whatever? So you're not necessarily negligent in slamming on your brakes to avoid an accident.
True.
But the duty, is there a duty by saying, I'm going to transport elderly people, so I should provide a bus that provides a safe environment, whether that's through seat belts or some other mechanism?
There is a duty, certainly, to transport employees, patients, whomever, in a safe and reasonable manner. There is that general duty. But when we get to the argument of, well, where is the breach here? Where would the negligence be? The negligence was that they undertook an obligation to do something and didn't do it in this instant. They created the duty by their conduct.
By undertaking to install seat belts and just not installing them in all of the rows? That's your argument?
By undertaking a duty to ensure that all Mayo Clinic shuttles that go between the two campuses are equipped front to back with seatbelts. That's what they undertook. That was the duty that they agreed to and that they have acknowledged.
I guess I'm a little puzzled by that they agreed to. The basis for that is simply Mr. Bergstrom's testimony that even though there's no contractual agreement and they're doing it, they may just think it's a good idea, independent of a contractual or...
If they did think that it was a good idea, that would still be an undertaking, gratuitous or otherwise, under 324.
Maybe I'm just completely missing the boat here, but I was kind of viewing an undertaking that I've undertook installing seatbelts and I did a bad job. So that would be, I would be liable for doing that. But I didn't undertake to install seatbelts. I didn't do it. So how do you undertake installing seatbelts when they don't actually install them?
Well, and I think that goes to the second prong Your Honor brought up, do they have a responsibility, do they have a duty to do so based upon their conduct, based upon their agreement, based upon how they conducted business? Did they have an obligation to do that? And then the next question is, well, did they do that? That's under 324. If under 324A...
But the first part, did they have an obligation? That turns on whether there was a contractual obligation or whether there was some sort of agreement as testified to by Mr. Bergstrom.
Or conduct, Your Honor. The main thrust of our argument, truthfully, is based upon restatement of torts 324A, that they voluntarily, that they gratuitously or otherwise, in this case they were paid, undertook the obligation. Once you undertake that obligation to provide seatbelts for the safety of others, you must do it reasonably. And if under A, if the failure to exercise reasonable care increases the risk of harm, there can be liability. And that's where we arrive today.
I mean, it sounds like you're almost going to prove a breach of contract that even though it wasn't written down, there was an understanding between Mayo and American Valet that there would be seatbelts and there weren't seatbelts, so there's a breach.
Well,
but I guess the way that I'm looking at the case, which I think is similar to the way Judge Cotani is, and if I'm looking at it incorrectly, please tell me, is that the tort is not safely transporting the Holcombs, and the breach of that duty is in not having seatbelts. I mean, that's how I'm conceiving the case, but I'm getting the sense I'm not conceiving it.
Well, I think you are including everything into one concept. You have to, before you can have a breach, before you can have negligence, you must have a duty. There has to be some obligation. That duty that the trial court didn't find, because the trial court focused simply on the contract, the four corners of the contract, and didn't concentrate on really where our focus is, and that is the creation of a duty under 324A, that somebody may take upon themselves a certain course of action. And that's what happened here. Whether it was contractual or not, American Valet set out to have all of the shuttles equipped with seatbelts for the Mayo Clinic account only, not their other accounts. That's what they were required to do. That's what they set out to do. So they created a duty.
For saying they're required to do it. That, assuming if Mr. Bergstrom's testimony is not admissible, they're required to. You're just saying their conduct suggests that it was required because they did it for this account but not for other accounts?
The requirement, meaning the understanding between American Valet and Mayo Clinic, and Your Honor, if we get to Mr. Bergstrom not being admissible, then the foundation for all of this probably does not exist. I would be happy to talk about Mr. Bergstrom's admissibility. I see I have just over 5 minutes left. I'd like to reserve some time. If there are
just and we'll give you a couple, maybe, sorry, an extra minute or so. But if you could address the admissibility.
The admissibility of Mr. Bergstrom is central to the contract, or the contract between Mayo Clinic and American Valet. He runs the shuttle program. He is the shuttle program. He is the account manager for American Valet for this account with Mayo Clinic. He is the liaison with Mayo Clinic. Without belaboring a number of things that he does, what his duties and responsibilities are, but he is responsible for the transportation of the patients and employees. He is responsible for the specifications of the shuttle purchases. He's responsible for the schedules, the maintenance. He's responsible for making sure that there are dedicated shuttles and backups for that Mayo Clinic account. He has taught the drivers the routes. He has taught them the policies and procedures for this account with Mayo Clinic.
But did he testify that he was aware of a contractual obligation to provide seatbelts?
Yes, he said several times, and let me find the. Mr. Bergstrom stated that seatbelts were required in all of the medical transport vehicles as a term of the agreement between American Valet and Mayo Clinic. That's our second statement of facts. He testified that American Valet took on the duty to have seatbelts because of its relationship with Mayo. That's our statement of facts number 28. He testified that it was a violation of the agreement between American Valet and Mayo to utilize transportation vehicles without seatbelts. He acknowledged that there was an agreement to do so. That's the contractual part. I want to come back, though, to the undertaking, the duty that they partook in, and specifically back to Mr. Bergstrom. Mr. Bergstrom had direct conversations with Mayo Clinic regarding the implementation of this program. He had direct conversations with both his supervisor and the owner of American Valet in procuring seatbelts, and made sure when they were being ordered to ensure that seatbelts were put in them. Why? Because the Mayo Clinic account required it. Now, whether that's contractual or they had agreed to do it, for the issue of duty is not really important. It's just a matter of how you get to that duty. Now, Mr. Bergstrom, he has personal knowledge of this. It is admissible under Rule 602 and certainly under 801 D2. He is a party. He's an employee of a party and can make such statements with his own knowledge, which he has. If there's no further questions, I'll reserve the rest of my time and sit down. Thank you.
Thank you, Mr. Harris. Mr. Petrie, when you're ready.
May it please the Court, my name is Sean Petrie, and I represent the Appalese American Valet in this matter. The trial court correctly granted summary judgment in this case, and that decision should be upheld for 3 reasons. One, there's no legal authority nor contractual obligation, as this panel pointed out, that requires seatbelts in these shuttle vehicles. Second, 324A does not apply. And then third, an additional issue that was not addressed by the trial court's ruling, but was raised in the motion, is that the appellants never provided any evidence of causation in this matter. First, though, is...
But, to ask you the same kinds of questions that we asked opposing counsel, the duty, at least as I understand it, is to transport safely.
I disagree with that, Your Honor, and here's why. The liability claim against my clients is not that they did anything wrong to improperly just transport the patients. They were not involved. They did nothing to cause the accident. That's been conceded. The only claim against my clients is that they failed to install seatbelts. So the duty, as construed by the pleadings in this case, is very narrow.
So there's no claim of negligence in being involved in the collision.
That's correct, Your Honor. According to the index of the record 62, we have a concession from plaintiff's counsel that says the mere fact that the accident occurred was not caused by, in any part, by appellee's conduct. The only claim is that we failed to provide the seatbelts.
But isn't there still a different question of, if I'm going to transport elderly people, I should have, whether they're seatbelts or some other type of restraining system, I should have something in place. Has that not been essentially alleged?
I think there's two problems with that analysis, Your Honor. First is that's a foreseeability factor, and foreseeability does not go to duty. That goes into what is a safe way to do something, which is foreseeability, which Gibson tells us is not a factor in determining a duty. But secondly, Arizona statute says you only are required to have seatbelts in the front seat of these vehicles. By expanding that duty to say, well, now it's in order to be safe, you have to have seatbelts in all of the areas of the seatbelt, you're contravening what the Arizona legislature has said is appropriate in these kinds of situations. And I don't think that's the scope of what we should be
deciding. Doesn't that just kind of create a per se violation as opposed to, couldn't you make the argument? It might not be terribly persuasive, but couldn't they argue to the jury that this is a transport vehicle that transports 12 people. They should have used seat belts, the same principles. They should understand that they're putting elderly people at risk. If you were transporting young people who have less likelihood perhaps of being injured with a small crash, isn't that not a factual question that the jurors could consider?
That is a factual question, but again, that goes to foreseeability. And Gibson tells us we don't look to foreseeability as an issue in determining duty. We look to other issues. We look to the relationship of the parties, such as the contract. We look to the Arizona statutes. We look to legal authority. We look to even 324, whether or not there was conduct that was undertaken. But the foreseeability as to what Your Honor is addressing does not go to the issue of duty.
So you're saying, counsel, that your client had no duty to act with reasonable care in performing this service for the Holcombs?
I think the question in this case is, is there a duty to provide seatbelts? And then if it's determined that there's a duty to provide seatbelts, did they perform that duty with reasonable care?
So the duty is not to transport safely.
Well, clearly there's a duty to transport patients safely, but the specific question of is there a duty to provide seatbelts is a different issue.
Well, and I guess that's what I'm struggling with, it seems like the duty is to transport safely. Then whether they should or should not have had seatbelts is a question of whether that duty has been breached or not, and that seems to be a factual question that's not for us to decide.
I disagree, Your Honor. I think that, again, the duty issue comes down to what does the contract say? Is there a requirement to have them? What does the statute say? Does that require you to have them?
Well, then the duty is not to then for us to be on the same page, and the duty is not to transport safely. The duty is either to have seatbelt or not.
And that is the duty question in this specific case, because that's what was alleged in this case, is that you failed to provide seatbelts, therefore you're liable to us.
So that there wasn't just a general allegation of you failed to take whatever measures were necessary to ensure safe transport of patients?
My understanding of the claims, Your Honor, is, and I believe this is what opposing counsel told you guys a few moments ago, which was the issue in this case is American Valet liable for not providing seatbelts?
Okay. Can you address why Mr. Bergstrom's testimony doesn't get them there?
Yes, Your Honor. As the trial court found, as an evidentiary ruling, which can only be disturbed based on an abuse of discretion, the trial court determined he did not have personal knowledge as to any contractual agreement, and this was based on a couple of things. One, he testified he never saw the contract or the specific agreements within that contract. Two, despite all these responsibilities he had, according to opposing counsel, the one responsibility he did not have, as he testified to, was negotiating the terms of that agreement. He was not party to those meetings when the terms of the contract were being decided. So he lacks foundation and personal knowledge as to what the contract requires.
But can he describe, though, the course of conduct that would suggest that there's a contractual agreement?
He can discuss the course of conduct, but that analysis goes to 324, but not to whether or not a duty exists under the contract. The duty under the contract is based on his own personal knowledge as to what the terms of that contract were, and his personal knowledge is that he did not see the contract. He did not participate in those negotiations. He did not have an understanding of what those agreements were. So, for two parts. One, there is no contractual obligation here that you can rely upon Mr. Bergstrom's testimony to support, because his testimony is inadmissible on those issues because he lacks foundation and personal knowledge. But then second, transitioning into 324A, which is the conduct issue which opposing counsel addressed to some extent. This panel correctly pointed out the argument that the appellees are making, which is the conduct would be if we installed a seatbelt into a vehicle and we improperly installed it, and that improper installation resulted in an injury, then potentially a duty would have existed under 324A. And we can understand this by looking at a couple of things. One, illustration 1 in the restatements discusses an example of a grocery store where you call out a repairman to fix a light. While he's fixing that light, he leaves it in a condition that's unsafe. The light falls down, it hits somebody in the head, and they're injured. The illustration does not discuss the example, which is what appellants are asking you to extend the analysis to, which is the repairman comes out, fixes this light, but it's the light on the opposite end of the store that ends up falling down and injuring somebody. And that's the same analysis that the Shanks versus Davy Tree Surgery court found in evaluating the scope of 324A. And in Shanks, the court said, yes, the tree trimming company came out, it did work on trees in the area of where the injury occurred, but it did not do work on the specific tree or the specific power line that injured the claimant in that case, and did not extend a duty under 324A there. And the reason why is because in order for liability to attach under 324A, one of three factors need to be met. And the factor that the appellants have focused on and conceded that the other two don't apply in their briefing is that the act must increase the risk of harm to the individual. The mere failure to act, as been set forth by jurisprudence in this jurisdiction and others, is insufficient to demonstrate an increase in the risk of harm. And you can see that again by turning to Shanks. In Shanks, the court specifically said that an increase to the risk of harm under 324A does not apply when there's only a failure to act, which is what we have in this case.
There could, in theory, if the failure to act prevented someone else from doing it, if they had said we're going to, we didn't. But you're saying unless that factor is there, unless you actually undertook to do something and did it in a deficient manner, that section doesn't apply. That's your position? That's
exactly right, Your Honor. Just like in the Shanks case, here, even if we agreed to provide, even if our conduct demonstrated a policy to provide seatbelts in these shuttle vehicles that were operated by Mayo, a failure to provide seatbelts in this specific shuttle is not sufficient to increase the risk of harm. That's what Shanks tells us. That's also what is told to us in the Tolinar case. In the Tolinar case, a very similar situation as in our case. In that case, you have a closed school campus. and the school is alleged to have failed to enforce its policy. And the court, in ruling on that, found no liability under 324A because there was no increase in the risk of harm, because a failure to enforce that policy did not increase the risk of harm, but rather exposed the students to the exact same normal risks of harm that they face as every other driver. The same is true here again. A failure to comply with the policy is not an affirmative act that increases the risk of harm. One additional case I found in preparing for today's oral argument is out of Kansas, the District Court of Kansas, and I know it's not binding on this court, but I think it's persuasive in this matter, and that's the Dines versus Vermeer manufacturing case, 752 F Sup 989. And in that case, you had an insurance company who was sued for failing to properly inspect a piece of farm equipment. And the court held there, just as we did in Shanks, just as we did in Tolinar, that you need an affirmative act in order to impose liability, and that merely allowing an existing risk to continue was insufficient to establish liability under 324A.
Counsel, did you supply a notice of supplemental authority to us?
I can provide that to you, Your Honor. I will put that together after today's proceedings.
Thank you.
So again, sorry, I'm getting a little dry mouth. Again, 324A does not apply because, one, as this court pointed out, there was no specific undertaking as related to the seatbelts. But two, even if there was a general policy for the company, a failure to exercise is insufficient to establish liability under 324A, increase of the risk of harm. Finally, Your Honor, I just want to bring up an argument that we made in the trial court, which is that there was absolutely no evidence of causation in this case, and a lack of evidence of causation is just as big of a failure of appellant's case as the failure to produce evidence of the duty.
But Judge Hanna didn't rely on that in reaching his conclusion, did he?
That's true, Your Honor. He did not. But a court of appeals can affirm a trial court summary judgment on any grounds as long as it was properly presented to the trial court. That's under CDT Inc. And that's what I'm asking for this court to do here, is to look at the arguments that we raised in our motion for summary judgment, which was properly presented there.
And that's on the basis that there was no evidence.
That's exactly right. It's not that there was some evidence that a reasonable inference could be drawn. This is an Orm School type situation where there was absolutely no evidence that a reasonable juror could infer from to impose liability on causation. And the argument is simply, yes, plaintiff suffered an injury in this accident. But the issue before us is not whether or not they suffered an injury in the accident. The issue is whether the lack of seatbelts caused or enhanced that injury. And I think in many ways this is similar to the cases of crashworthiness, when you make a claim against a car manufacturer or a car designer. In those cases, in order to establish liability, not only must you demonstrate that someone was injured in the accident, but you must also establish that the defective manufacturer or the defective design caused, contributed, or exacerbated those injuries.
That seems to be a serious factual question, though.
It would be if there was evidence presented on it, but that's the problem here. There's no expert testimony. There's no medical records that say that the injuries were more severe because of a lack of seatbelts. There's no medical testimony, biomechanical testimony, any evidence. There is zero evidence that says because of the lack of seatbelts, the injury was more severe. If there would have been testimony from a doctor, if there would have been an expert opinion, then I would agree with you, Honor, that it is a question of fact. But in the complete absence of evidence, causation can be determined as a matter of law, as noted by Orm School. Ultimately, Your Honors, the trial court properly granted summary judgment in this case. There is no legal requirement for seatbelts. The statutes say very clearly it is only required in the front seat of the shuttle vans. There is no contractual requirement for these seatbelts. The contract is very clear on its face what the requirements are, and seatbelts is not one of them. The only contrary testimony, or the only contrary evidence to that, is the inadmissible testimony of Mr. Borgstrom. Third, Restatement 324A does not apply because there was no undertaking and there was no increase in the risk of harm. And finally, there was absolutely no evidence of causation in this case that the lack of seatbelts exacerbated, contributed, or caused the appellant's injuries. And for these reasons, we ask that the ruling of the trial court be affirmed.
Thank you, counsel. Mr. Harris?
Thank you, Your Honors. Let me return to what counsel said a moment ago about Judge Hanna finding that 324A did not apply. When you look at the order, he simply says 324A is inapplicable without explanation, without elaboration. We don't know what he was thinking. However, if you go to the oral argument, if you go to the transcript, which is the index record 86, it is abundantly clear that the trial court focuses only on subpart C of 324A, reliance. He asks the questions. He is focused individually on whether or not the plaintiffs relied upon this undertaking by American Valet. And under 324A, it is an or scenario. Subpart C, reliance, is not a part of our case. It is subpart A that states quite clearly that if you undertake a duty and don't do it reasonably, then liability attaches. Trial court never got to that analysis.
So the duty was not to transport safety. The duty was to have the seatbelt on.
The duty was, well, there is a general duty of safe transportation, certainly.
But what was the allegation in the complaint? Was it that they breached the duty to provide seatbelts because they undertook to install seatbelts and they did not do so?
Without having looked at the complaint in quite a while, I believe there were allegations of negligence, general negligence, as well as failure to provide the seatbelt.
But the argument in response to the motion for summary judgment, what was the argument there? Was it just that it was duty to install a seatbelt?
That American Valet undertook a duty to install seatbelts, failed to install the seatbelts. They were therefore breach of that duty, but that wasn't a subject of summary judgment. Simply the initial issue was whether or not the duty existed to have seatbelts in those particular vans. If
we were to disagree with your position that they undertook the duty to install seatbelts, what's your best argument for reversal?
If they did not undertake the duty, then you get back to the extrinsic evidence of Mr. Bergstrom telling us that there was an agreement, that the course and conduct of that agreement was to have seatbelts because that's what American Valet provided. That's what Mayo Clinic required of them, and that it was a breach of the agreement not to have seatbelts. That's the testimony. That's the unrefuted testimony. There is no other evidence in this case but for what Mr. Bergstrom has told us regarding the obligation, regarding the undertaking, and regarding the duty that they've acknowledged.
Counsel, can you just, I know your time is up, can you briefly talk about causation?
Sure. Causation, number one, is certainly a question of fact for the jury. But in this particular case, there is a plethora of information about causation. Let me say first and foremost that this accident that happened here, where the plaintiffs came off of their seats and struck other parts of the van and each other, a layman can determine whether or not there was causation of injuries by virtue of what happened, by virtue of the facts that the plaintiffs have testified to. The medical records, and this is in the briefs, I believe, the medical records are replete with references to causation with knee injury for Mrs. Holcomb, with elbow injuries to Mr. Holcomb from striking portions of the vehicle. It's throughout the medical records that the doctors give that testimony. The disclosures have provided that the doctors will testify regarding causation. Simply the inferences that can be drawn about the forces going forward, it provides causation. Again, there's a number of areas here where causation is clear, but again, should be left to the jury to decide.
Thank you, counsel.
Thank you, Mr. Harris.
Thank you.
Counsel, thank you for your briefs and your presentation here today. It was very helpful. We will take the matter under advisement and issue a written ruling in due course. The court will now stand in recess to allow the next case to set up for their oral argument. We'll be staying on the bench during the recess before our next case. Thank you, counsel.
Thank you.